Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we're going to talk about something that everybody has an opinion on, and it's a pretty spicy topic, the death penalty. I'll have more for you in just a minute. I'm not generally a big fan of the death penalty for several reasons. First, it is quite easily applied in a way that can be, I would say it has a disparate impact. Not necessarily that it's applied with a true intent to be racially discriminatory, but I think sometimes that's how it's perceived, and I think sometimes it does more harm than it does good. I also feel like it doesn't occur with enough rapidity to ever really be a deterrent for somebody. You know, you'll read in the newspaper that a crime that was committed in 1985, somebody was finally executed yesterday for. It kind of makes you think, well, didn't they really get a life sentence with a little topper on the end? And I think that's probably a pretty fair representation of the death penalty. And then you have states like Illinois and California where the governors just decide, the heck with it, let's not have a death penalty. Oh, let's add Wisconsin to that too, although that was a legislative decision. So you have these situations where the death penalty can be just not applied in a particularly rational way. But that doesn't mean that it's not useful and that it shouldn't be applied in certain instances. For example, when someone kills a child with malice, people who intentionally hurt other people's children, people who kidnap children, and particularly people who kill them, I don't believe there is very much that you can do to rehabilitate those people. People like John Wayne Gacy, who killed multiple serial killers. Again, you are not going to rehabilitate a serial killer. You're just not. When they go to prison, they're probably going to continue to practice serial killing. There have been a lot of cases where people convicted of murder went to prison and got convicted of murder again inside the prison. I'm convinced that the entire usefulness of the death penalty is wrapped up in the concept of making it an effective deterrent. So to summarize, my main problem with the death penalty is that it's just not effective. But in summary, there are some places where it is just so appropriate that even if it isn't particularly effective as a deterrent, it needs to be done. In addition to killing children, I think killing police officers, firefighters, paramedics, people who engage in public service is one of those areas where we really need to have the death penalty because, frankly, you have to protect the people who protect you. And so the case we're going to talk about today involves a gentleman by the name of Kevin Johnson. And Kevin Johnson was a pretty angry guy, apparently, because he had a misdemeanor assault conviction. Now, a misdemeanor assault conviction in Missouri usually means that you're not going to go to jail. You're probably not even going to go to the county jail. And that's especially true if you get probation. But a lot of times people just ignore probation, or when they get probation, they don't honor it. They don't look at this as a second chance and say, hey, guess what? The judge gave me a break, and so I'm going to turn my life around and be a good guy. Apparently that never occurred to Kevin Johnson. As a result of being on probation, he didn't show up and had a probation violation warrant. Now, a probation violation warrant is no big deal. They knock on your door, and they say, hey, we're here. You got to come in. You got to post bond. You got to show up for the probation violation hearing. And, of course, at the probation violation hearing, you can make any excuse you want to, and some judges accept them and some judges don't. You might wind up doing 30 days in the county jail, but at the end of the day, what's going to happen is that you're still going to be on probation. You're not going to have to serve out the rest of your sentence. Judges tend to be very lenient. They want to make probation work. Unfortunately, there are just some people that it's not going to work for, and I think Kevin was probably one of those, although we'll never know. Because while the police are out looking for him, they park in front of his house because they see his car in front of his house. And while they're sitting there waiting for him to poke his head out of the house and go out to his car or walk around his yard or do some other thing that might call him to their attention, in the house next door, Kevin Johnson's brother begins to suffer a seizure. Now, this is in 2005. There's plenty of paramedics and fire medics and that kind of thing, but in 911, the first thing that gets dispatched is the police, and there are police sitting right outside. So they dash over there and they do their best. They treat the young man until the paramedics get there. The paramedics take over. They take him to the hospital where he's diagnosed with a heart attack, which resulted from a pre-existing cardiac condition. Some people are never disturbed by the facts. They are instead motivated by their own biases. And in this case, he had a significant bias against the police. Kevin Johnson did. And so he became convinced that instead of going over there to treat his brother, they went over there to abuse his brother to get information about him. And he came away with the idea that they had killed his brother. So he went out to his car when the police had left, got his handgun, and a few minutes later there was a fireworks call where a sergeant by the name of McEntee came. And Sergeant McEntee came and was talking to 3 juveniles who were at the side of his car. In other words, the driver's side of his car, he's up talking to the juveniles. And Kevin Johnson shows up at the passenger side. He drops the window, and Kevin Johnson says, "You killed my brother," adding a few other words that suggested maybe that he was doing something that he shouldn't have been doing, and proceeded to shoot the sergeant 5 times, once in the head. He then grabbed his gun and went cursing down the street. He ran into his mom and he said, "Those people," he didn't actually use the word people, "those people killed my brother and I'm getting even." And his mother said, "No, that's not true." But he ignored his mother and walked on. In the meantime, Sergeant McEntee's car rolls down, hits another car, and he can't talk because one of the bullets hit him in the head, and he gets out of the car and sits on his knees. And our friend here, Kevin, sees him, comes over, and shoots him 2 more times in the head, resulting in what I'm sure was a closed coffin funeral for Sergeant McEntee. He killed him. Before you get to a trial, the prosecutor has to determine whether or not a case is proper for the invocation of the death penalty. And there are statutory aggravating factors, one of which is that the crime was heinous. Another is that it involved a police officer in the performance of his duties. And if you meet these statutory aggravating factors, you can seek the death penalty. Now, nowhere in those statutory aggravating or statutory mitigating factors does race play a role. But the assertion by the defense in that case was that the death penalty was sought solely because the officer killed was white and Kevin Johnson was black. So the first trial resulted in a hung jury. There really was not any doubt, I don't think, about the guilt of Kevin Johnson because one of the juveniles who was talking to the officer was shot by Johnson and testified against him. They had information from his mother that said, "No, I told him that wasn't true." All of these things sort of called into question the idea that he wasn't guilty. But he still contested guilt and he was found guilty. Now, I would suggest to you that if Kevin Johnson had done the right thing and had come in and said, "Look, I plead guilty, just take the death penalty off the table and I'll plead guilty," that the prosecutor in that case, Robert McCulloch, would probably have said, yes, you're right. I'll take the death penalty off. You'll spend the rest of your life in a little 8x10 cell where you can't hurt anybody else except your cellmate. But that didn't happen. So they prosecuted the case through, and the first trial ended in a hung jury. The second trial, the jury was out for 4 hours. And they came back, they found the three statutory aggravating factors and sentenced him to death. In Missouri, every death penalty case is reviewed by the state Supreme Court. And they do that for several reasons. One, they do it for proportionality in order to make sure that, basically, to be somewhat facetious here, that we're not executing people for jaywalking, and also that we are not allowing people to get a free pass on serial killing. So they look at it from that standpoint. They look at it and they do a regular review, just like any other appellate court would, of the facts of the case. So what happened in Kevin Johnson's case? Well, let's take a look at what the Supreme Court said in its latest filing. This court affirmed Johnson's conviction on direct appeal, and the United States Supreme Court denied certiorari. Johnson filed a motion in state court for post-conviction relief under Rule 2915, and after a hearing, this motion was overruled. This court affirmed that denial, and the Supreme Court denied certiorari. Johnson thereafter sought relief in this court on multiple occasions. Each time, this court rejected his claims and denied relief. And then it goes through a couple of the situations where he sought relief. That isn't where it ended, though, because, as I told you before, when you have an appeal and you have a criminal conviction, you have the right of federal habeas corpus relief. So, Johnson also sought habeas relief in the federal courts, which rejected each of his claims and denied relief. There's a Johnson versus Steele Westlaw opinion there from 2018, and then the Eighth Circuit denying certificate of appealability and affirming the district court's refusal to recuse in 2021. And the certiorari was denied on that by the Supreme Court in 2022. After Johnson exhausted all legal avenues for relief, including direct appeal and various post-conviction relief settings, this court sustained the state's motion to set Johnson's execution date. Now, I would point out that, as we see on this slide, that Johnson asserted 11 points on direct appeal, all which were denied. Relevant here, Johnson argued the circuit court erred in overruling a challenge pursuant to Batson. And Johnson argued his sentence was disproportionate and that his sentence should be set aside due to the prosecutor's discretion in seeking the death penalty. Johnson made another 11 claims in his state post-conviction relief proceedings, all of which were denied. Relevant here, he argued counsel ineffectively argued the Batson challenge regarding juror Cotman. So one of the claims that Mr. Johnson made in his appeal was that during jury selection there was a juror by the name of Cotman. She worked as a social worker or something like that in one of the state entities that had provided services to Johnson as a child. Now, it didn't say she had personally done that, but she was in that office. And as a result of that, the prosecutor said, well, she worked in this organization and I just don't think she can be a fair juror. And as a peremptory challenge, that challenge was granted. Now, he did not specify that Cotman was black and that's why he was excluding her, but that was Johnson's challenge, that she was being excluded because she was black. I don't know if that's the case, and I don't think anybody knows if that's the case, but that was the assertion that was being made. So how does this case reach the Supreme Court again? Well, I'll explain. There was a statute that was passed in 2021, and here is what it says. A prosecuting or circuit attorney in the jurisdiction in which a person was convicted of an offense may file a motion to vacate or set aside the judgment at any time if he or she has information that the convicted person may be innocent or may have been erroneously convicted. The circuit court in which the person was convicted shall have jurisdiction and authority to consider, hear, and decide the motion. Well, the statute also calls for there to be a hearing. Now, this is where we get into some of the inside baseball with regard to how courts work. And that is, courts really like it if you give them enough time to decide issues. And one of the things that this statute required a circuit court to do was to look at the trial of the case, look at the appeals, consider all the issues that were raised there, consider the issues that are being raised by this special prosecutor's motion, and then make a determination. Well, interestingly enough, instead of having the St. Louis Circuit Prosecutor bring this motion through its Conviction Integrity Unit, instead what happened is the prosecutor's office decided it had a conflict of interest, meaning that one of the people who had represented Johnson in the circuit court as a defense attorney was now working for the prosecutor's office. And this happens all the time. People who were prosecutors become defenders. People who were defenders become prosecutors. It's the way the world works. Because if you have expertise in that area of the law, you tend to apply it in the area that will do you the most good. And so that's the way the situation was. And as a result, the prosecutors decided they had a conflict. Now, the Supreme Court takes a pretty dim view of that assertion. In fact, what they say is, look, there's no reason they had to conflict the entire office. They could have walled him off from this. They could have said, look, you can have no information about this and have absolutely nothing to do with this claim. That's not what they did. They decided the office had a conflict of interest instead of the prosecutor. So getting further into the weeds of the inside baseball, when somebody has a death penalty case and it's been affirmed all the way up to the United States Supreme Court and back down, it doesn't get carried out in Missouri until the state Supreme Court issues what's called a death warrant, which is a really nice letter that starts greetings, which just kills me. Well, it actually kills them. It says greetings. You've been, your time's up, dude. You're going to be put to death on such and such a day at such an hour. So, as you might guess, that sort of quickens the pulse. And he had already filed, once all of his appeals were exhausted, he'd filed with the Conviction Integrity Unit once it was established. And then, as you might guess, the state moved for a death warrant. And the Supreme Court said, we're going to town on November 29th, 2022. And now the special prosecutor comes in, does some preliminary work, and about 2 weeks before the death warrant is set to be executed upon, he files a motion in the circuit court and says, hey, we got to hold a hearing. And I'm not ready for the hearing. I haven't gotten everything put together, but we got to hold a hearing. So you need to issue a stay of execution. Except the statute does not provide for a stay of execution. Nothing in the statute gives anybody the right to ask for a stay of execution. There are two people who have a right to ask for a stay of execution. One of those is the Attorney General, and the other is the person who's going to be put to death. But in this situation, when you ask for a stay of execution, you have to have a reason that supports your stay of execution. And in this particular case, it isn't the convicted felon here who has the right to ask, because he doesn't have any chance of getting his conviction overturned. All of his appeals have been denied, and he's out of options. So now he's using the state's process, and he's got somebody at the state's Conviction Integrity Unit asking to have this stay imported, and that's not going to happen. So the circuit court wrestles with this idea and says, look, I don't have time, given what you've got. You got 2 weeks before this happens. I don't have time to set a hearing and conduct an evidentiary hearing on this, plus review all of this stuff on the file. And that's true. The court has other cases. Indeed, the court may very well be trying other cases even as that motion is filed. Be that as it may, the court says, I can't do this. I'm overruling your motion for stay, and I'm overruling your motion to vacate the judgment. So there are two reasons why you can vacate this judgment. One of them is factual innocence. So, it wasn't Lee Harvey Oswald, it was the guy on the grassy knoll. You can prove that now. Okay, Lee Harvey Oswald gets out of jail, except he ain't getting out of where he has it. Anyway, that's the theory. And then the other reason is if his conviction was constitutionally infirm. In other words, if the Constitution was violated in order to get the conviction, somebody used false testimony, somebody hid evidence from the defense, somebody violated any of the many, many principles involved in case law that say you can't do things, if any of those things happened, then and only then can you get a reversal or at least a vacator of the conviction, which just gives Johnson another chance to be retried. And of course, the whole aim is, when this occurred, the shooting occurred in 2005, the trial occurred a couple of years later, and as a result of that, there were still a lot of people around who remembered the events and probably saw the procession of police cars on TV. And as a result, the theory is that now in 2022 he might have a better chance of avoiding the death penalty, or in the alternative, that the prosecutor's office, since after all it's seeking to reverse the conviction, might not even seek the death penalty. So that creates an interesting conundrum as it comes before the Missouri Supreme Court. Because the Missouri Supreme Court, again, sort of as an inside baseball thing, doesn't like the idea that this appears to be playing with the timeline and trying to force a stay, and it also appears to be trying to force a stay of execution because of this requirement to hold a hearing. So you wait so long until there's no time to hold a hearing, then you ask for a hearing, and now you have to have a stay. Well, the Supreme Court, they don't go there. They look at this and they say that, look, all of this guy's claims have been rejected on appeal. The Batson claim against the juror, Cotman, was rejected at every level. The circuit court, the appeals court, the federal district court, and the federal appellate court, and the United States Supreme Court. 5 different courts looked at it. They all rejected it. And the idea that for some reason that the death penalty was only sought because Kevin Johnson was black, that also was looked at by all of those courts, and all of those courts determined that that was a specious argument. So as a result, the Supreme Court issued an opinion where it said, we reject this, we are going to reject the stay of execution, and we believe the execution should be carried out. Now, there were 2 dissents. One of those is from Judge Patricia Breckenridge, who is an excellent judge, and she just felt like a stay would have delayed things a couple of days, but it probably would not have resulted in a different outcome. At least that's what I read from her dissent. And Judge Draper also joined with her in that dissent. And I respect a judge who wants to err on the side of life. I do. And I think Judge Breckenridge did the right thing in that regard in offering that dissent. If I had been on the Supreme Court, would I have come down on the practical side or on the aspirational side? I don't know the answer to that. I think that's a moral question, and one that sort of goes back to my findings of, is the death penalty really the right answer? So, again, I don't know how I would come out on that, but I do think that all of the judges who looked at this are principled judges, and they reached the opinion that they reached. And on November 29th, 2022, Mr. Johnson was put to death in the death chamber at Bonne Terre, Missouri. And he apologized to his victims. Again, there was absolutely no doubt as to his guilt or innocence. But they continued, they, meaning his lawyers, continued to say that he was put to death solely because he was black. I believe that does short shrift to the prosecutor's work and the work of the police agencies involved, because I believe very strongly that he was put to death because he killed a police officer. And again, in my opinion, if you commit a felony and you're subject to arrest and you decide you want to get into a gunfight with a police officer and you win, you are still going to lose, because you are more likely than not going to go to the death chamber. And that's probably where you belong. So that's the sad story of Kevin Johnson and his attempt to get his death sentence put aside. It's an interesting case. I will link to the description in the comments down below. As always, if you have questions or comments, again, please keep them family friendly. There's a lot of people that participate here. And leave them in the comments down below. As always, like, share, subscribe, do all the things that everybody on YouTube asks you to do, because it does help us out with the algorithm, and that's a good thing for all of us. Thanks again for watching, and have a terrific day.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.